Do you have a loved one who's suffering from addiction issues, mental health issues, or a combination of both? If so, we can help you. In Florida, there's a process called a Marchman Act, in which case you can get help for a loved one who's suffering from addiction issues that also have a combined mental health effect or just addiction issues by themselves. This case often involves clients who might have other types of cases as well, such as criminal cases, that have brought this to their family's attention. If there isn't a criminal case as well, we can just handle it separately as a straight Marchman Act. Now, the Marchman Act process is a two-part process. The first petition is a petition for involuntary assessment, and the second petition is a petition for involuntary treatment. Now, the petition for involuntary assessment requires sworn testimony of a loved one, of a family member, to go ahead and explain how your family member has lost the power of self-control with respect to alcohol, drugs, or both, to the extent that they are a danger to themselves or to others, they can't care for themselves, or a variety of other factors. We need to be able to have an itemized list of facts and circumstances that have happened involving your loved one to explain to the court why the court should intervene and force them to have an involuntary assessment. If the court reads the petition and finds it legally sufficient, they're going to set an evidentiary hearing on this, or they're going to issue an order regarding an involuntary assessment. Ultimately, you're going to have your loved one ordered to go to a Marchman Act receiving facility. Now, at the facility, your loved one is going to have an assessment, and the assessment is going to vary, but it's going to be by an independent professional who's trained regarding substances, and this individual is going to test them. They're going to see if they have any substances in their system at the time that they're brought into the facility, and they're going to question them regarding their history and question family members regarding the history of the individual. And of course, they're going to read the Marchman Act. After the assessment is done, they're going to write a report and be prepared to testify in front of the court. Once the report is complete, we have to go on to the second petition. Now, the second petition is a petition for involuntary treatment, and you have to allege why you need to force your loved one into treatment and how much treatment you would like. For the first round of court order, you can order your loved one into treatment up to 90 days, and that has to be done after an evidentiary hearing with the court. So be prepared to testify and explain to the judge what has happened with your loved one. You might need to bring witnesses. You certainly need to explain the whole set of circumstances that have surrounded your loved one and why the court needs to intervene. If the court orders them into treatment, then the next phase happens, and this might be an extension of the petition for involuntary treatment, and this needs to be filed well in advance of the expiration of the timeline and before the expiration of the 90 days.